Welcome. We are visiting the values of the Constitution of India. The central aspect of this document is the distribution of the sovereignty. Of it, the central focus again will be upon distribution of the legislative sovereignty, legislative powers. To appreciate the importance of it, we have to go back to the goddess of justice. We take it, goddess of justice remains blindfolded. To some, it may look like that iron and gold can be compared by weight only. While the setup of this to be appreciated is that goddess of justice remains blindfolded so that there can be a glimpse through eyes of the mind. So the physical things do not distract and mind glimpses the true values. So goddess of justice remains blindfolded to glimpse through eyes of the mind and gives a call. The call of the goddess of justice is in the form, listen, soul of the justice, where honesty is simply to put facts on record as these are. Honesty is simply to put facts on record as these are. Truthfulness is simply to evaluate facts as per law. See what is the call. Goddess of justice remains blindfolded so that there can be a glimpse through eyes of the mind. And goddess of justice gives the call, listen, soul of the justice. So one is to listen, soul of the justice, and one is not to see through eyes, as through eyes only the physical things will come into play. But what we will hear, it will be a scintilled form. So listen, soul of the justice, as that honesty is simply to put facts on record as these are. And truthfulness is simply to evaluate facts as per law. The faithfulness is simply to follow judgments of the superior courts. Worship is simply to follow procedure established by law. Prayer is simply to reach at justice as per the command of the soul of the goddess. So, when we are appreciating and when we are evaluating our judicial system, then we have to be through these simple values of this system. Facts should remain facts and not to be mixed up with anything else. The evaluation of the fact is to be as per law. And then this evaluation of law is to be as is interpreted by these courts of the higher justice, higher courts. And further, procedure established by law is to be followed. And one is to aim at, to reach at the justice as is the soul of our system. Now, for it, what we have to evaluate or what we have to learn is the division of legislative sovereignty, which is as union list, state list, and concurrent list. Our constitution has made three lists. First is the union list of the topics, aspects, areas, domains within which Parliament can legislate, can make laws. State list in the list of topics, domains, areas where the states can legislate, legislatures can legislate. As such, there is some area, there is some domain, there are certain topics, there are certain aspects where both union and state, union parliament and state legislatures can legislate. Now, the criminal justice, the procedures, the establishment of courts, and all connected aspects with which we are concerned as students of law, as lawyers, as litigants, is the concurrent list. Because the concurrent list is the list in respect of which both parliament and state legislatures can legislate. The very fact that both parliament and state legislatures are within their power and within their responsibility and within their duty to legislate in respect of the concurrent list. And when the concurrent list covers the criminal law procedures, the institutional setups, courts, and all that. Therefore, we as lawyers have to be very, very cautious, have to be very, very specific to see which provision is the provision made in the union enactment, which provision is made in the state enactment, which of the parliamentary enactment stands amended by a particular state legislature. So each law, first of all, is to be put in a specific brackets as that such and such provision is the union legislated provision, such and such provision is the state legislated provision. So when, say, in respect of criminal procedure code, we will be going for the trials in a particular territorial jurisdiction, say within Haryana, then we have to be very, very specific as that whether the code of criminal procedure, which is a union enactment, stands amended or not, and if amended, to what extent, in what form, by the state legislature of Haryana. So the procedure, the law during trial in the territory of Haryana with respect to the crimes in respect of which the responsibility, jurisdiction, and all other steps are to be taken by the state of Haryana, by the prosecutor representing the state of Haryana. Then those procedural amendments or that law of the Haryana state legislature will be having predominant effect. In fact, that on that particular point on which there is such and such amendment is to be applied, is to be enforced, is to be acted upon, and our entire analysis, our entire logic, our entire steps are to be as per the Haryana state legislative provisions. So if, say, for the similar situation, we are in a state of Punjab, then the amendments of the state of Haryana are having no effect whatsoever, and it will be taken that those are not there, and the law of procedure, criminal code of criminal procedure is to be as is the enactment of the parliament. However, if the Punjab state itself as well has come up with certain amendments, has made its law, has made specific procedural arrangements, legislated, enacted to be enforced, then those, as far as the state of Punjab is concerned, are to be applied that way. Now, while we are through the provisions of the Code of Criminal Procedure, then we have noticed that it specifically provides that the procedure provided in this code is to be applied upon all criminal trials. However, this procedure is subject to the special procedures which have been provided under special enactments. Those special enactments may be of the Union of India, and those specific enactments can also be of the individual particular states. Therefore, the trials to be followed, to be chased, to be conducted are to be as per the procedure established by law. This takes us back to Article 21 of the Constitution of India. The Article 21 of the Constitution of India is within the Fundamental Rights chapter. So this provision that liberty and life are only subject to the procedure established by law. This procedure established by law, as far as the Code of Criminal Procedure is concerned, takes us to the concurrent list. And the concurrent list is the list in respect of which both union and state have their powers and responsibilities. So, the special laws or special provisions or specific amendments are to be taken care of, and the whole trial is to be as per the procedure established by law. And if some trial steps are not in accordance with law, means if one for any reason is not conscious of the particular amendments or particular specific provisions of particular territories, then the trial will become bad in law. It will be unconstitutional. Therefore, the first principles which say that facts be put in their pure forms. Facts are to be interpreted as per the law. The procedure is to be as per the legislative sanctions behind it. And then we also have to be conscious as that the constitutional command is that judgment of the High Court of a state is binding upon all the courts of that state. And the principle which stands synthilled is that the judgment of a court of state A is certainly binding over all the courts of state A. However, the judgment of state High Court of State A is also lawful binding judgment in state B as well, provided the High Court of State B has not adjudicated otherwise. However, as far as the apex court judgments are concerned, those have universal binding effect throughout the country, throughout each and every territory component of the Union of India. So each state and whole of Union is governed by the binding effect of the judgment of the Supreme Court. It is in this background that we shall glimpse the list of the Union legislative provisions, the area, the aspects, the domains, the topics in respect of which Parliament can make laws shall be appreciated. Likewise, appreciation is to be of the state list, but for us, more focus shall remain upon the concurrent list, as the justice, particularly the criminal justice, is the subject of the concurrent list. We will be taking up specific illustrations, but before that, let us remind to ourselves that criminal justice apparatus of our country, as it is having many facets, many aspects. It's a big institutional network, and each institution as such, as each organ of the justice system, deserves to be analyzed and appreciated distinctively. And it is only with this concentrative eye upon the features of every individual organ of the justice system that we may be in a position to ensure that everything goes as per law, whether or not particular person coming and claiming to be the prosecutor deserves to be analyzed as only the authorized persons, only the persons with proper authorizations are to be permitted to get designated as prosecutors for a particular trial in a particular case. Likewise, though there are initial presumptions that anybody coming forward and claiming himself to be a prosecutor or as an advocate be taken on the face of it, however, it is a presumption and it is a rebuttable presumption. Therefore, the court machinery, as well as the parties and the defense and the prosecutors have to verify, have to justify, have to ensure that one claiming himself to be prosecutor or one conducting as a prosecutor, or one claiming himself to be defense counsel, and one acting as a defense counsel, are in fact true lawfully appointed prosecutor and defense counsel or not. Because if there is any fraud, if there is a miscommunication, if there is a bad communication, if there is a gap of some procedural steps, because in many ways, many correspondence documents are of not permanent nature, some are of temporary nature, some are of for particular durations, and after the expiry of the duration, naturally the vesting powers also cease. However, under some conventions, some another situations, it is just being taken for granted as if the extensions will follow, which many times don't follow, and then the steps taken in between on such presumptions are to become illegal. This all is of realistic importance, as each trial is to have effect upon the individuals. So particular individual on trial in a particular case, if during particular phase of the trial stands situated that the particular prosecutor or particular defense counsel have not been the lawfully appointed prosecutor, lawfully appointed defense counsel, then at the subsequent stages, it will become really a very, very hard situation. Retrials, fresh trials, and many other connected aspects will follow. And those we can imagine of how big, strenuous situations those will be. Likewise, the courts, the presiding officers, the notifications with respect to powers, etc., of the presiding officers, the vesting of powers, divesting of powers, and all that also come into play, and one is to remain conscious about it. Then the amendments happening on substantive as well as on the procedural laws. And one of the very, very complex situation is if in between the trial particular procedure stands changed, then when need will be to test it by the dictum, there is no vested interest in the law procedure will confront us as to the particular trial is to continue under the procedure in terms of which the trial has initiated, or that the new amendment, the amended procedure coming into force in that very territory is to be applicable and is to be adopted or not. Likewise, the substantive provisions as well have their implications. In civil law and in criminal law, the civil procedure and criminal procedure, substantive civil law provisions and substantive criminal law provisions have their distinct test stones to judge. This way, the scenario as comes to be is that the professional duties of the advocates are really of great challenge. With times, this responsibility is getting more and more intensified, particularly when the substantive and procedural laws remain the same, but the tools, techniques, the advancement of technologies, and the other natural factors like the epidemic through which we are passing and the consequential steps taken for the conduct of the proceedings, etc., have their great implications. How we are absorbing it, how we are transiting with it, how we are getting adjusted with it in itself at present may look like just simple a academic type of situation. However, after 6 months or after 1 year, when we will be revisiting to the trial phase having passed through during this period, and when it will come to the conclusions as that there has been some unlawful deviations, then we have to pay for it. Therefore, during this phase in particular, we, the lawyers, have to be extra cautious as our illiterate litigants are having a hopeful look only towards their lawyers, and lawyers themselves have been placed in hard situations. In any way, we as human beings have great sense of adaptability, and we hope that the goddess of justice will ever smile and will be satisfied that we, the responsibility holders of the justice system, are coming up to the expectations. Thank you very much.
Thank you, sir.